welcome everybody to Kuch Khaas, and Babar Sattar will be talking to us about the 18th Amendment. He says that it's very boring and he hopes that he'll be talking about more interesting things in the future. But I'm the one who asked him to come and talk about the 18th Amendment because frankly I was interested in it. So do come up with suggestions then what we would like to hear and talk about the next time, so we can try and get him to speak on something that he find more inspiring. I hope we all learn lots.
Before actually getting to the 18th Amendment, I thought I'd just say a few things about the Constitution itself. Or just the constitutional process, the way I understand it, so that it provides some kind of a background as to why I've formed the opinion that I have formed of how various people look at and relate to the Constitution. And maybe this is, everyone already knows about these things, so it's just probably going to be a reiteration. I think one of the questions that people ask is the Constitution now perfect? Will the Constitution become perfect? What are the things that you do to a Constitution to make it perfect? The other important thing I think is that this is a consensual document. It is supposed to be a majority document. Given its nature, and given the fact that even in theory 2/3 of the parliamentarians have to even change this document, there has to be a majority consensus in the country, which then means that there are going to be certain ideas which are evolving in the society, and they're not going to be reflected by this document. Only when the society gets to a stage where there is that majority consensus over a principle, then it gets reflected, or it should get reflected in the Constitution, meaning that there's always going to be a gap between liberal or progressive aspirations and whether or not they're documented in the Constitution, and that frustration kind of stays. And so we've had part of the criticism, hopefully we will get to that soon. Part of the criticism of this amendment also is that it's not gone far enough. Things that it should have done, which it hasn't done, which is also fair criticism, but that's always going to be there. There are people who said that this is a bad amendment because it will politicize the judges, because they say it's a bad amendment because it will undermine the independence of the judiciary. They say it's a bad amendment because parliamentarians are going to talk about the conduct of judges, which they're not supposed to under the Constitution, under Article 68 as a prohibition. I think it's a great amendment. Up until now, the way judges were appointed was the High Court, the Chief Justice of the High Court would just pull some names, ask people, friends, who should be a judge, get those names together, send them off to the Chief Minister, who then give his opinion on those names, get intelligence reports. The Governor would step in and say, okay, these two guys are good as well, let's include them. All those names then come to the federal government, they play around, get intelligence reports, send to the Chief Justice, he takes out certain names, the Chief Justice of Pakistan adds new names, then it goes to the Prime Minister, who again, so there's this whole negotiation process which is informal, which is not transparent, nobody knows how the names get in, how they get out, who says what. A lot of time compromises are made, okay, if there are 10 slots, the Chief Justice gets 3 people in, the Chief Minister gets 3 people in, or the Prime Minister gets 3 people in, no accountability. And these judges then stay, they have security for tenure, which means that they cannot be removed once they become judges, and they should be removed. So the process has to be transparent, because the Chief Justice do not have angels as Chief Justice, as we all know. And so their discretion, totally unguided, cannot be trusted with appointments as important as these. Now at least there's going to be conversation. People will sit across the table and say, no, I don't support this guy because, look at this conduct. He did this as a lawyer, he's got no reported judgments, or he did this, that, the other. So there's going to be some kind of conversation about it, which is great. And in my opinion, independence of a judge doesn't really come from how he gets appointed. It comes from the fact that he cannot be removed. So you make somebody a judge. Obviously there's some limits to that, but once a half-decent person becomes a judge, you cannot remove them. He's going to stay as that for 15 years. That is what gives people that kind of independence, that they're independent of things like that. So I think that's a good amendment. The fourth thing that this bill has done, the amendment has done, is it's trying to renegotiate the relationship between sector and provinces. So we've heard a lot about how the concurrent list is gone. So within the Constitution, there was a federal legislative list, which is two parts, which is what the Parliament, the Senate, and the National Assembly would legislate on those subjects. Then there was a concurrent legislative list, and here both the federal Parliament and the provincial assemblies could legislate. And if there was a conflict between a provincial legislation and a federal legislation, the federal legislation would prevail. So I think that's a flaw. And if tensions continue to build, maybe people will sit together and think about some of these things to change that part of the Constitution which does all this. I'll just stop there. I know we'll have an interesting conversation about what's going to happen next week in the Supreme Court or some of that. The only thing that in the end I would say is that law has its limits, which we have to recognize. It's a text, like any other text, it's not self-implementing. People implement it. So it has limits. To the extent that a law is not backed by social consensus, or law is not backed by a political movement, it's pretty worthless. So that challenge is there. Just because certain things are in the Constitution is not going to make them happen. With that limitation, and people will point out that if that is a limitation, then why happens? So that argument goes on and on. Let's just stop there.
Pakistan, we live in a situation where virtually every taxi driver can tell you what 58(2)(b) means, but nobody can tell you what their fundamental rights as a citizen are, or under which provisions of the Constitution those actually derive from. So why is there this lack of consciousness of individual rights in this country, and what can we do to fix it or to redeem it?
I think eventually it's only constitutionalism and rule of law being practiced on a continuous basis without hypocrisy. So long as the courts, again, uphold certain rights immediately, they're immediately starting to look at the 18th Amendment, they look at the Nawaz Sharif's case and condone 8 years of delay from the limitation process. But on an everyday basis, somebody who goes to the district court doesn't get that kind of response from the law. Till the time benefits of law are not trickling down, what's the point? Is what people say. And I think to some extent we're all to blame. Like as a lawyer, you advise your client in a certain way, and you tell them how to delay the process of law. If he's a landlord, you tell him one thing. If he's a tenant, you tell him another thing, and you help him. So I think the lawyers, the judges, the rest of the society, we're all kind of implicitly breaching or contravening law when it is to our advantage. And I think that culture of constitutionalism, it's going to take time till we actually get there. And I think the simplest way is that consequences of actions should flow. If I do something silly, I should be punished. But you get a ticket on Mardula, you call up your friend who's the SP and you say, "Yaar, mera ticket lag gaya, to kuch chada de." It's 200 rupees, but to the extent that you know somebody, you don't mind giving him that call, and he in response is going to say, "Yaar, ticket lag gaya, to paise de do."
I'm actually looking at the flip side of that coin, which is very few people actually stand up and say, "I'm going to do this because it's my right to do so." And that Green Book says it is my right. That is the kind of consciousness that I don't see enough of over here. Yes, people do the negative and get off the hook and ring people.
But if I might say, I
Sure.
think the main reason for that is because we don't have the confidence in the judicial system. If I want to fight, yes, if I want to fight for my right as given to me by the
But do you know what that right is?
Well, I don't think I'm a good case in point. I do, because I read the Constitution.
Yeah.
Most people don't. But even if you did know, the advice you get is, कचेरी कोर्ट के रखते तुम्हारे पता नहीं कितने साल तक चक्कर लगते रहेंगे, वो तो कुछ नहीं करेंगे. I think we shall try and stop now, because I'm sure Babar's quite tired. But all I can say is this definitely was not boring. I hope you agree. Not at all. We hope to have many more.
3 days on Article 280 can surely go on.
Thank you very much.
Thank you very much.